I think that there are two different questions here. One is the issue of the arrests, and if there are requests regarding the lawfulness of the arrest itself, it can be presented to the judges who will decide on it. Mm-hmm. Second question is the question of jurisdiction of the ICC crimes allegedly committed in Philippines before its withdrawal from the Rome Statute. And that's something on which the ICC has already been clear, whether it in regard to Philippines or Burundi, which is another state that also withdrew from the ICC Rome Statute. So the court's jurisprudence has already indicated that the ICC retains jurisdiction even after the withdrawal of a state, but only for the crimes that are allegedly were committed during the period when the state was a state party to the ICC Rome Statute. So for the Philippines, I think from 2011 or 2012 until 2019, this is the period in which Philippines was a state party. So crimes allegedly committed during this period in Philippines were under the ICC jurisdiction and remain under jurisdiction. The withdrawal does not affect these obligations and this jurisdiction of the ICC. It only affects the future. So after the withdrawal become effective, if new crimes are committed, then they will not fall under the ICC jurisdiction. But the jurisdiction was already there during the period when the Philippines were a state party, or Burundi, which is the other example, and then the exercise of the jurisdiction can be after the withdrawal. There is no problem in that, but the application of the law on international treaties means that this jurisdiction was already existing, and thus the ICC can retain it.
After the arrest of the former President Duterte, was it necessary for the Interpol and the Philippine authorities to bring Duterte first to a local court in the Philippines before bringing him here in The Hague?
Well, this is a matter that depends on each state internal laws. So in general theory, there is a process when a person is arrested in a certain country before he is surrendered to the ICC. But these processes can be very different from one state to another, and I'm no expert in the Philippines laws. So this is a matter of internal law on which I cannot actually decide. As I mentioned, the legal process before surrendering a suspect to the ICC can vary from one country to another. I can simply say if there is any challenge to the lawfulness and legality of the arrest, it can be submitted to the judges, and then judges will decide on that. I will not speculate on a possible request and what might be the outcome. I think that the important thing to remember is the idea that there are international accountability mechanisms in order to ensure that when there is an arrest warrant, that the states cooperate with the court. Interpol is one of the channels to help with these mechanisms. And as we have indicated before, we're also grateful to the Philippines' commitment to this international accountability mechanism, because it's important. It's important to clarify what is the reality of what happened. It's important for the victims to see that justice is working for them. It's important also even for the suspects to clarify whether they are really guilty or not. So the process has to take place in order to ensure that truth is revealed, and then if there is a responsibility, then the persons are held accountable. I think that there is an arrest warrant that was issued by the ICC judges, and of course, naturally, when an arrest warrant is delivered, then it is communicated to the states on the territories of which the suspect might be present. So it's totally normal that after an arrest warrant is delivered, we contact the states to ensure the surrender of the arrest and surrender of the suspect. As I was mentioning, we need to distinguish the issue of the jurisdiction from before and after the withdrawal of the Philippines. Crimes that allegedly were committed before the withdrawal of the Philippines from the ICC Rome Statute remains under ICC jurisdiction. So the ICC has jurisdiction over these past alleged crimes, but there is no jurisdiction currently over Philippines for if crimes would be committed after this withdrawal. So the issue of jurisdiction is different from the issue of the cooperation. Now, the issue of the cooperation, as I said, it was for the Philippines authorities to cooperate with the international accountability mechanisms and with the ICC, and we are really grateful that this was done to make the truth clear for everyone and to see the process of justice working. As for the cooperation with the Philippines, as I mentioned, after an ICC pretrial chamber delivers an arrest warrant, it has to be communicated to the different states in order to ensure the arrest and surrender of a suspect. So it's a natural process. First, I think all cases before the ICC are about very serious crimes, about mass crimes. By definition, the jurisdiction of the ICC is about war crimes, crimes against humanity, and genocide, in certain cases, the crime of aggression. These are very serious and very grave crimes. All cases before the ICC are important. And for us, it's very important to always remember that why we are doing all of this, it's because victims have suffered and they deserve to know the truth. And accountability has to be there in order to ensure for the future, a better future for everyone. Now, that being said, we need to understand that historically, most of the cases before the ICC were related to conflicts in Africa. But that's because the African states themselves had asked the ICC to open an investigation about it, or because the Security Council of the United Nations also asked the ICC to open an investigation in relation to Libya and Sudan, also in Africa. But that was a certain amount of years ago. Since then, the ICC has opened other investigations, whether in regard to Ukraine, to Afghanistan, to Philippines, to Palestine, and in other places. So it's no longer only about a certain region. The ICC jurisdiction is over 125 states that are parties to the ICC Rome Statute, over their territories, if anyone is committing crimes on their territories, even from non-state parties, or if crimes are committed by their citizens anywhere. That's the parameters of the ICC jurisdiction. And these parameters have to be applied consistently over all these places. And that's what we are trying to do. So for us, we are working in a legal framework according to the Rome Statute that was adopted by the states. The states created this institution. And the work of the court is actually to implement this legal framework. And while there were historical reasons why we started with a certain number of investigations, but currently we have investigation over 4 different continents, and I think of the cases that are before the ICC are very serious, very important, and we need more cooperation from all different states, also because there is a certain number of arrest warrants that have not yet been implemented, and that is important also that the states cooperate to arrest and surrender these other suspects. As I mentioned, we do not look at the situations or at the crimes depending on where they were committed in this or that continent. We have investigations in 4 different continents, and we have already issued arrest warrants in a number of situations, not only related to Africa, but also related to Asia and to Ukraine and so on. So we think that it's important that we keep working in this direction, and we hope that there will be more cooperation from the states to implement these other arrest warrants as well. Well, we need to explain the principle of complementarity before the ICC. As you mentioned, the ICC is a court of a last resort. What does that mean? That means that the primary responsibility is with the national tribunals. But if they are unwilling or unable, or if they haven't opened cases, then the ICC can intervene because there is no other venue for the victims. Now, that means that if there is no case against the same individual for the same alleged criminal conduct, then the ICC can go ahead with the case. The principle of complementarity is not a general judgment over the ability of the system. It's a specific judgment over this specific case. So that means that if there were, for example, national proceedings against the same suspect for the same alleged conducts, then his or her defense team, or even the state that is concerned, can raise a challenge to the admissibility of this case before the ICC and say that the ICC should stop the case because there is already a case that has started before the national tribunals, and it's substantially the same case, and that the national tribunals are genuine about it. They have to demonstrate that. In these conditions, the ICC would stop the case before it. But if there are no cases, or if the case is about another suspect, or if the case is about different alleged criminal conducts by the same suspect, then substantially it's not the same case. And that means that the principle of complementarity cannot be applicable on this specific case. So we are not making a general statement about the Filipinos tribunals. We are only saying that for this specific case, at this moment, we are not seeing that there is a legal process in the Philippines about this specific individual and for this specific allegations. If they were, then his defense team or the Philippines can actually ask the court to stop this case if they can prove that there are genuine proceedings against the same person for substantially the same alleged conduct. I cannot speculate on that. If there will be a request either about the lawfulness of the arrest or about an interim release, it will be for the judges to decide on it. And I don't know if the defense will do it, and I cannot speculate on what the judges will actually decide. Well, we need to understand that the principle is to respect the presumption of innocence. So, as a matter of principle, we consider that every suspect is innocent unless and until there is a trial after which he or she are convicted beyond any reasonable doubt. And that presumption of innocence means that the principle should be the freedom of the suspects and not their detention. When the judges issue an arrest warrant, that means that they believe that the arrest of this specific individual is necessary, either because he or she are still committing crimes, or because he or she would not appear before the court and cooperate with it if the court issued a summons to appear and not an arrest warrant, or because they believe that maybe without arresting this individual, they may be creating obstacles or threats to the proceedings, to the investigation, or to the witnesses. So they have to justify that. An interim release can be requested if there is a possibility to put in place measures and conditions to ensure that if a person is released, none of that would happen, and that this person will be brought again before the court if the judge's orders so. And that means that there is a different set of conditions that needs to be checked. First, in which country this person might want to be released. Does this country accept this release? If the court is ordering certain conditions and measures to be put in place to ensure that he will not be in contact with this or that he will not be threatening the investigation, that he will be brought again before the court when the judge's order. Does the country accept these conditions and measures or not, and so on. So as a matter of general principle, there is all these conditions and questions need to be discussed before the judges, and then the judges will decide whether or not to grant an interim interim release with conditions, as I mentioned. It has happened in the past that certain persons were granted interim release or conditional release on different situations, sometimes temporarily for specific, sometimes personal conditions, and then back to the detention center. But again, it would be for the judges to decide on that if there will be a request to that effect.
So even personal reasons?
There has been short releases, for example, for private life circumstances for certain individuals in the past. We, as a matter of principle, respect this privacy, so we cannot actually discuss in details what actually happened, but that was very short moment. And again, it's the judges who decide on the interim release as a matter of principle. They decide also on the conditions and the duration. Remember the full details of these different cases, but there is no link between the interim release and the final decision, because the interim release can happen at a pre-trial phase or at a trial phase. It's up to the judges to decide on it and on its conditions, on its duration, and it's not a prejudgment of whether this person will actually be acquitted or not. These are two different and separate questions.
All right.
You have to understand that the judges can only decide based on what is presented before them, either by the prosecution or by the victim's lawyers or by the defense lawyers. So they are not taking into account any other elements that are not in the files before them. So this type of actions is showing support to certain suspects, but it's not part of the findings before the judges, so it cannot be taken into account by the judges. But something that has to be also understood is that the judges, of course, do understand how to say, the question of ensuring that a person is brought before them. And in certain instances, the question of whether this person can be kind of at large and not return before the ICC. So what kind of networks or capacity he might be able to use in order can also be taken into account for the questions of interim releases and stuff like that. But it's not about the petitions or the demonstrations or stuff like that. This is, I understand, it's supporters showing their support to a certain suspect, but it's not a question that is before the judges. It's not presented to them, so it doesn't have an impact on the proceedings. We need to understand that the judges, as I mentioned, can only decide based on what is presented before them by the parties and participants to the proceedings. So if there is no standing for a certain individual, meaning that they are not representing one of the parties, that they are representing the victims, they are not admitted in a certain way to the legal proceedings, then they cannot make petitions to the judges. Okay. Again, I would not speculate on the potential outcome of a potential request. First, we'll see if the defense will present a request for interim release, and then we will have to see what the judges will decide. Now, as a matter of principle, the ICC can enter into general agreements for interim release or for other purposes with different states, but can also enter into ad hoc agreements with certain states for specific cases. This will depend on the request and on the willingness of a certain state to accept and to implement the measures and conditions that might be ordered by the judges. So this is something that we prefer not to speculate on. We have to respect the proceedings, the integrity of the proceedings, and to respect that the judges are impartial and they are doing their job in a professional way and based on the legal rules and the evidence that is presented before them. Again, it's a matter that will have to be decided by the judges. I explained a little bit the general framework of ensuring that a person will reappear before the judges when he or she are ordered to do so, that they will not be putting in danger the proceedings and would not be continuing to commit crimes and so on. Now, the technical measures and conditions have to be decided on a case-by-case basis by the judges and have to be accepted by a certain state for it to be ordered by the judges. So I would prefer, as I mentioned, not to speculate, to respect the process and to respect the impartiality of the judges.
Okay, in the history of ICC trials, has there been a case where supporters of an accused have camped outside at the ICC? Has there been a case where supporters of an accused have camped outside at the ICC or even the detention facility, as is happening now?
I know that usually every media has type of questions about the first to happen before the court, and I know also that for every single situation and for every single country, they feel that their case is a bit different from the others. But the reality for us, all the situations are very important. They are all about very serious and grave crimes, and we don't look at it in a different way based on this country or that, this profile of the suspect or this. And we have been working for over 20 years. We have seen many different situations, and I can assure you that yes, it has happened before that we had demonstrations and different ways of supporters showing their support to the suspect. I think that the main thing that we need to understand is justice acts in an impartial way. And justice has to act in the time that is necessary for justice. We have to respect the process. It's not about being passionate. It's about being objective and impartial and applying the law and checking the evidence. So victims are respected. That's what we are working about. So we understand that there is always a lot of passion in the realm of social media, and we understand that by definition, the persons that are suspected by the ICC, they are suspected of very serious crimes and mass crimes. So by definition, they retain a certain amount of power and they have supporters. But we do not consider that this should be something that would be kind of distracting our focus from what we have to do, which is our core tasks and core responsibility towards the victims and toward the international community, which is to apply the law in an objective and impartial way. And we trust that in the social media there will always be some passionate and heated individuals, and we understand that there is also good people that will be actually trying to show the objective nature of things. And we call on everyone to actually rely on the ICC channels for the correct information and not on rumors, and to understand that rumors might be putting in danger sometimes potential victims or potential witnesses, and sometimes people that have nothing to do. It might be a wrong name or a similar name, and they should avoid that because it's a matter of responsibility. It's putting in danger the lives of individuals with no reason sometimes. So they should trust the justice and trust the impartiality and the objectivity of the work of justice.
We understand.
Dating Presidente Rodrigo Duterte. Ang mangyayari dito ay sasabihin lang siya kung ano yung kaso laban sa kanya, sisiguraduhin na naintindihan niya yung kaso niya, anong mga karapatan niya, yun lamang. Now, may mga dahilan kami, pero susubukan namin ipaliban itong kauna-unahang pagdinig na ito. Pero itong mamayang alas 2 ng hapon, magkakaroon ng kauna-unahang pagdinig sa kaso ni dating Presidente Rodrigo Duterte. Ang nangyayari dito ay sasabihin lang siya kung ano yung kaso laban sa kanya, sisiguraduhin na naintindihan niya yung kaso niya at anong mga karapatan niya, yun lamang. Now, may mga dahilan kami, pero susubukan namin ipaliban itong kauna-unahang pagdinig na ito. Pero itong dahilan namin ay pribadong ipararating sa mga maestrado. Sa ngayon ay iisa pa lang ang na-recognize na lawyer, si Attorney Medialdea, dahil siya ngayong kasama. Pero we have filled up all the documents para mapasama din ako dun sa team of counsels. Now, I'm the lead of the ICC, and we have also retained another member of this council who is British. So initially, there will be 3 of us starting as counsels. The other one is Hoffman, Attorney Hoffman of the British Bar. So 2 of us from the List Council and Attorney Medialdea. The Vice President, of course, is here as a member of the council, and she will be in the gallery to witness the first hearing. So hindi ko po alam kung mapagbibigyan yung hinihiling namin na ipagpaliban, pero wala naman akong dahilan para naisip para hindi mapagbigyan yan kasi wala naman pupuntahan si Presidente Rodrigo Duterte sa kulungan dito. So ipagpaliban nyo na ngayon kasi hindi pa namin nakikita ang dating Presidente. Buong araw, kahapon, hindi siya nakita dahil di umano siya ay binigyan ng medical examination. So ngayon pa lang, ang problema dito sa ICC ay daming papel bago mo makita. So we submitted the form to visit him para hindi naman kauna-unang beses makikita sila ni Vice President dito sa hukuman. Ako, I feel strongly that before the hearing, not only I should be able to have access to him as a member of the List Council of the Court, but the family should have access to him. So actually, ang priority ko is to make sure magkita muna silang mag-ama. Dahil hindi pa alam ni Presidente na nandito si Presidente. It's not proper naman na hindi alam ng ama na nandito yung anak niya. So I'm more or less attending on this first day of hearing, a family matter, and I want them to see each other outside of the court first so they can have a private.
Attorney, what do you call the postponement? Is there a legal term for that?
Wala naman, it's the same. Alam mo yun, the procedure is similar to Philippine procedure. Ang difference lang is before it arraignment and before it goes to proper trial, meron tinatawag na confirmation of charges. And in the confirmation of charges, they will establish that there really is probable cause and that there really is jurisdiction. But I do not know if I can be registered in time for the hearing today, but in addition to the postponement, if I am recognized today, and I'm not sure yet, because we just did all the papers today, I will also bring the issue of the illegality of the arrest of the former president that should lead to the court losing its jurisdiction. And I would be citing a case from the Constitutional Court of South Africa that an illegal arrest is sufficient to divest the court of jurisdiction. This is a right from by the Commission. In addition to the lack of jurisdiction, because we had withdrawn from our membership, and of course the preliminary investigation commenced beyond the date. But of course, everything hinges on if I will be recognized today. But right now, we have to leave because we want to see the president before he is brought to court.
So just to be clear, sir, you said it has been sent privately already. Yung request to postpone this particular
No,
initial
it
hearing.
has not been. It will have to be asked in the hearing today.
Today. Okay.
Paano po pag hindi po na pagbibigyan ng
Sir,
ano po ang next plan ninyo?
Ang mangyayari lang naman kung yung mga pagbibigyan is sasabihin lang kung ano yung nature charges, but it is not. It is just to make sure he understands the nature of the charges against him, not an arraignment. In court na, wala nang panahon kasi. Kasi alam nyo, itong notice came very late also. We had just arrived yesterday, and of course, nauna sila. VP came next evening of yesterday, and I came yesterday then, no? And actually, yesterday we had no access to him because he was undergoing medical exam, no? And he was not here, no? And for a while, we were even alarmed where he was, but he was apparently subjected to medical examination. So it's only now. So bigyan na muna natin na makita muna yung mag-ama. Okay? Can we do that? I think he is in the detention facility. We're going to the detention facility now. Please don't follow kasi hindi rin kayo magbigyan ng access. Ha?